So we are really looking forward to our first keynote Q&A today with Antonia Apps. Antonia, until last week, was the regional director of the SEC's New York regional office. Now she has a new role, acting deputy director of enforcement. Congratulations. Prior to joining the SEC, Antonia was a litigation partner at Milbank, and she also previously served as an AUSA in the Southern District for over 7 years, where she led cases including the prosecution of the hedge fund SAC Capital. Welcome, Antonia, and thank you.
Thanks for having me.
And our moderator today is George Canellos. George is a partner in the New York office of Milbank, where he serves as the global head of the firm's litigation and arbitration group. George previously served as the director of the SEC's Division of Enforcement and also as an AUSA in the Southern District. George, thanks for moderating, and I'll turn it over to you.
All right. So you're the last man standing, huh?
Well, not exactly. I wouldn't quite go that far.
Well, we had the last panel of people wildly speculating as to what might be happening within the SEC, and here we have an actual opportunity to talk to someone in continuing leadership at the SEC. So we're in the first few days of a new administration in which things presumably will change in some ways, and there's great uncertainty at these times. You don't even have a new chair, much less a new permanent director of enforcement. How do you? General question, how do you navigate your responsibilities when faced with so much uncertainty as to the direction of the new administration?
Well, let me start with the standard disclaimer. My remarks today reflect my personal views, not necessarily those of the Commission, the commissioners, or its staff. So I would say, first of all, we're continuing to move the work of the division forward. If issues come up that we're unsure about how the current commission would think about it, or what their policy views would be, we consult with them. And of course, the acting director, Sam Walden, and I have been observing the three current commissioners, acting chairman Ueda, Hester Peirce, and Caroline Crenshaw, who are currently on the commission members, were commission members in the last administration. So I think from those observations, I think we have a decent sense of where they come out on particular policy positions and views. And so we have a good instinct in knowing where to go as an initial matter and where we need additional clarity. We communicate up to the commissioners and their staff. A lot of this is public record, as some folks observed on the prior panel. There have been dissents by commissioners, then Commissioner Ueda, now acting chairman Ueda, and Hester Peirce, who are now in the majority of the commission. So a lot of you can sort of figure out which way they may be leaning on particular subject matters in any event. And we take each case as it comes. We will communicate with the teams if we think there's a change in direction. And of course, we internally communicate more broadly with the enforcement division overall if we're going to have a different approach on particular issues, whether it's remedies or something substantive that comes before us.
Are some things, Antonia, effectively on hold, pending the transition to a new permanent administration? For example, some types of investigations or the resolution of some pending investigations?
No, I don't think we can say anything blanket is blank. There's no blanket rule that things are on hold. We're looking at things as they come up. We're taking a close look at any case that comes before, that we, as the acting deputy and and Sam may decide to sort of make a recommendation to the commission. So there's no blanket, things are out of the box on hold. We're evaluating the docket closely in coordination with the commissioner and acting chairman offices.
I note that there were a flurry of cases filed in the last quarter, and the departing chair took the unusual step of putting out a press release announcing this enforcement statistics for the last quarter. Was there a big push to resolve cases before the end of the last administration?
I don't think I can comment on whether there was a big push. Obviously, you see the statistics. I will say, since the last panel decided that statistics are always an issue, I guess we got a jump start on fiscal year 25. I'm making no comment, of course, about whether statistics are or are not an issue, but the last panel concluded that they're always an issue. Look, obviously there were a lot of cases that were brought before the Commission in the first quarter of fiscal year 25, and I would say it's less of a, it's slowed down a little bit, but which is a good thing, because in a transition, we need to make sure we're taking each step, each day as it comes, and making sure we properly consider each case before we recommend it to the Commission.
So, does the uncertainty that exists in SEC practice, do you see it presenting practical impediments to you? Putting aside your desire to move matters along, do you see it presenting practical impediments? For example, defense lawyers slow-walking cases, unwilling to settle cases for lack of clarity as to what enforcement policy will be in the months to come. Do you perceive that to be taking place at all?
Well, I will say, look, we're 4 days in, so I'm not sure I could say from my current perch that I can observe anybody slow-walking anything. I mean, clearly, in the 2 years that I spent at the agency before taking on this role as regional director of the New York office, there were times where you could see that defense counsel were deliberately slow-walking cases. I don't think that is a good thing in any administration. That's my personal view. I think it's important to work cooperatively with the staff in every investigation. I'm not sure what now would be the motivation for anyone. Maybe I should put that question back to you, George, on the defense side.
I would slow walk if I could get a better result. I think most people in the room would, right?
Well,
but
you presume to know what a better result is.
Maybe the fire sales are available right now, though.
Okay. Needless to say, he did not bet that one with me.
And Antonia,
no fire sales are available. This is not the way to think about this.
Joking aside, has the new acting chair or commission provided the division with any kind of direction on any points that you can share?
Well, I mean, I guess if you, I can't get into internal guidance, obviously, but and certainly if you're asking generally about priorities, it's way too early for any articulation of priorities. We don't, obviously the acting chairman is even only a week into his new role, and Chair Atkins has yet to be confirmed and join the agency. If you're looking for tea leaves or indications of policy positions of currently the majority of the commission, Acting Chairman Ueda and Hester Peirce, there's a lot of signals in their dissenting voices that they've made over the years. The current makeup of the commission, the three commissioners, acting chairman, and the two other commissioners were part of the last administration. And I will note that most decisions were unanimous. The majority of decisions were unanimous, and where there was disagreement, they often made their views known publicly. So, I mean, that's really all I can share in terms of how you might think about priorities, enforcement priorities going forward. And of course, as you know, having been in the role, George, there are always market events or situations that overtake any chair's enforcement priorities, and the agency is always going to respond to those market events and protect the integrity of the markets, regardless of what may be a list of enforcement priorities that a future director or even the chair may make known to the public.
Yeah, I think that sometimes in this period of uncertainty between administrations, you have an acting chair who will take a case-by-case approach, and you learn to tease out their views and the views of the commission on a case-by-case basis. Other times they will say, we want to stay the course on A, B, or C policy or action. We'd like to moderate our position on X, Y, or Z position and provide that kind of guidance. It sounds like this is a little bit more case by case, at least as far as you can discern from the first few days.
Right. I mean, I think the elephant in the room, and I think you were going to ask me about this at some point, is when it comes to crypto, it's no surprise that this administration is going to be taking a very different approach. The acting chairman announced on January 21st the launch of the Crypto Task Force, which is going to be headed by Hester Peirce. I'm sure all of you know that. And that's going to be dedicated to developing a comprehensive regulatory framework for crypto assets. And that task force is already drawn from staff across the agency, and it's going to collaborate with the public to set a sensible regulatory path and provide much needed clarity in the space. So I think it's fair to say that we may be turning the page on regulation by enforcement in the crypto space. And there's other developments in crypto, as this audience I'm sure knows, and the president issued an executive order on digital financial technology and created a working group. The acting chairman's a member of the working group. And of course, last week the SEC rescinded Staff Accounting Bulletin 121, SAB 121, in SAB 122. And that, of course, was the rule that provided interpretive guidance for an entity's obligations to safeguard crypto assets and requiring the entity to recognize crypto assets as a liability on the balance sheet. So you can well imagine that there's a sea change in that space, and obviously it's too early for me to comment on any specific or categories of crypto cases, but of course we're evaluating all of that within the agency.
So I note also there's the president has formed a working group on crypto that includes the head of the SEC, who I assume is the acting chair presently, as well as the Attorney General and the Treasury Secretary and the CFTC's chair. And the SEC has a parallel internal group, right?
Right. I mean, I don't know if parallel is the word I would use, but the first business day
right.
That acting chairman Ueda was in the job, he announced the creation of this task force, as I said, to be headed by Commissioner Hester Peirce.
And what is there any intended to be any formal interaction between the task force created by the SEC and the president's broader senior administration working group?
Well, I mean, I can't get into sort of the internal dialogue that's happening, other than to say it's obviously the acting chairman is a member of the working group, and I think Commissioner Hester Peirce brings a deep expertise, as does the chairman, but in the space, and they're obviously going to work towards developing some kind of comprehensive regulatory framework.
And is enforcement also represented on the internal SEC task force?
I really can't get into which staff members have populated the internal task force, but I think the thrust of the task force, you can look at the public-facing statements on this, is, as I said, to turn the page on the notion of regulation by enforcement. So you can draw your conclusions from that.
Okay. And can you make any comments about the implications of the task force or the president's working group for the day-to-day enforcement of potential violations of the securities laws in the crypto markets?
Yeah, I mean, unfortunately, I can't really comment on any specific case or categories of cases. We are evaluating all the cases at this time.
Okay. So a few other sort of substantive topics. One of the more significant sweeps of the last administration involved bringing charges against broker-dealers as well as investment advisors for record-keeping violations for so-called off-channel communications. Can you let us know, where does that sweep stand now?
Yeah. Well, so let me start by making a couple of general observations, and a lot of this is taking cues from the commissioner's prior public statements on these cases and their voting record. So first of all, I think all of the commissioners have recognized the importance of record keeping by regulated entities. I think even in a recent order, Commissioners Hester Peirce and Acting Chairman Mark Ueda said effectively, if business is being conducting, using communications are outside the reach of firm compliance, it makes it very difficult, and I'm paraphrasing here, it makes it very difficult for firm compliance and the commission to ensure compliance with our rules and regulations. And of course, where there's been a complete failure in record keeping, obligations, the Commission has garnered unanimous support in favor of those cases in the past. And I think the view is that the industry has gotten the message, and has a lot of the industry has adopted practices and policies to ensure compliance, and that's a good thing. I guess I'll just say one other observation. If you look at what's public record, a dissent by then Commissioners Peirce and Ueda in the Catalyst case, I think their view was where firms have taken steps, acted in good faith, and tried to comply, we're not going to insist on the standard of perfection. I mean, that's the thrust of the Catalyst defense. I'm not making any new news here. So that's really sort of some general observations. And again, all I can really say about the cases before it is that we're evaluating all of those cases. So perhaps I should have, right after my disclaimer, said a sort of an expectation setting disclaimer at the same time. 4 days in, it's unfortunately I can't articulate or deliver too much new policy news.
I believe that the last panel gave a lot of attention to Section 13B22 of the Exchange Act, which requires public companies to have internal accounting controls that are reasonably designed to achieve compliance with GAAP and to assure management accountability for assets, among other things. And there have been a couple of controversial cases in that area where the accounting controls have been extended to the arena of cyber and have been interpreted and enforced as requiring reasonably designed cyber controls. Similarly, the same section in some settled cases have been employed to police for what the Commission views as improper stock buyback practices by issuers, and in particular, basically buybacks that may be based on material non-public information. Do you see any change in the Commission's posture vis-a-vis interpretation of that particular provision and those precedents?
Again, it's too early to give guidance, but to, I guess, another observation, which is to the extent that the Commission has brought settled actions based on 13B2B outside of the narrow accounting controls context, there have been dissents by the Republican commissioners, not just Commissioners Peirce and then Commissioner Ueda, but of course there was another Republican commissioner in an earlier case in 2020, Commissioner Elad Reisman, who dissented to, with respect to as to the application of that provision outside of the accounting controls arena. And as you note, SolarWinds, I think the first time it was litigated that the provision should apply, I guess, to cybersecurity as an asset. The district court there disagreed with the Commission's views about the breadth of the application of that section. And so, obviously we take all precedent into account amongst other arguments in considering what kind of cases will go forward. But I think those are helpful data points, even if I want to make clear I'm not announcing any new policy with respect to the provision.
I think I can read those tea leaves, Antonia, thanks. Please just tell me it's a good question and you can't answer it. But will there be changes to how the Commission, do you expect that there will be changes to how the Commission approaches officer and director bars or industry bars?
Yes, I would say we are going to be much more thoughtful in assessing whether the imposition of a particular remedy, such as an officer and director bar or a penny stock bar, but to what extent the imposition of that remedy is necessary to serve the public interest. Can you point to how the public interest is served? And so I think you are likely to see movement on those types of penalties in the future. And there have certainly been it's a voting record as to the positions of the current commissioner person and acting Chairman Ueda on penalties and bars in the past.
Well, let me just say that if that's the case, I commend the commission for that. I'm just going to offer a little bit of commentary on that. O&D bars, for example, are only available when there's a 10B charge or a 17A1 charge, so it does require scienter. But of course, conduct that we call fraud, and that gets resolved as fraud, runs the spectrum from someone acting in a way that someone views as extremely negligent, rising to the level of recklessness, involving a truthful statement but alleged to be misleading by omission on one side, with no harm to anyone, to Bernie Madoff on the other side. So the spectrum of conduct is so broad that the reflexive approach that the commission has typically taken of, if it's a 10B, I need a bar, just doesn't seem to allow for the commission to take into account the individual nuances of such a broad spectrum of cases. So I think it's welcome news that the division at least will be giving thought to whether an O&D bar is appropriate in every case. Same with industry bars. Since I have you on a roll, how about corporate penalties? Any thoughts?
Needless to say, it's the commission hasn't announced any new policy with respect to corporate penalties. What I can say is I think it's helpful, and I think Sam and I find it helpful in an analysis or in terms of thinking about corporate penalties, is to look back to the guidance that the commission issued in 2006. And obviously there the key...
When then Commissioner Atkins was on the commission and an animating force behind that guidance.
Yes, right. That is true. But just for those who are not intimately familiar with the 2006 guidance, although you may want to get more familiar with it, it turns on whether the issuer's violation has provided an improper benefit to shareholders, or conversely, the violation has resulted in harm to shareholders. And I think the guidance is we should not be punishing innocent shareholders twice, once for the violative conduct, and then again with a penalty, and it's more appropriate to consider seeking penalties from the culpable individual offenders who are acting for the corporation. Of course, a whole host of other factors are considered in corporate penalties: deterrence, the need to encourage firms to adopt good compliance programs, the egregiousness and pervasiveness of the conduct, harm to third parties, perhaps, and the remedial steps and cooperation that the firm has taken. And on the remedial steps, I just want to emphasize that certainly, even in the last administration, in the 2 years that I was at the helm of the New York office, firms that took remedial steps early, sometimes even in response to examination deficiency letters, always put themselves in a much better position for either no enforcement action or an action with much reduced penalties, or perhaps no penalty at all, if the firm engaged in not just remediation but cooperation. If you've remediated the problem, you've already inserted, changed the policies, you have somebody overseeing it, you would have less of a need for an ICC, for example. Those are all good practices for avoiding higher penalties or sometimes even commission action at all.
Well, they were, but I don't think, for example, in the sweep involving off-channel communications, not a single firm got any traction in solving their problems in advance. So there was years of notice. Most firms took steps, and including bringing in outside consultants, and I don't think a single one of them avoided having an independent consultant imposed upon them. So this seems like it might be an inflection point in practice.
No, I'm not going to. First of all, just for the record, I was recused from the off-channel sweep in the prior administration, so I'm not making any comments with respect to that, as I draw upon my experience from the regional director spot that I held for a couple of years. I did see in a lot of other cases, and again, I'm making no comment on the off-channel sweep, so a lot of other cases, a real impact that taking such proactive measures could have on the outcome of an action, an enforcement investigation or action.
Great, including bringing in outside consultants who may not be independent within the SEC definition, but nevertheless are in spirit addressing the problem with some significant degree of independence.
Right.
Excellent. Turning to some process questions, Antonia. So under Chairman Gensler, the power to issue formal orders of investigation was delegated to the director. And I think that delegation took place approximately in the year 2010. And in administrations that preceded 2010, formal orders of investigation could only be entered by the commission itself on, with detailed memos submitted by the division recommending the commencement of or the initiation of an order. Do you expect any change in that practice?
Again, I can't announce any change. I'm not authorized to announce any change. And I will also just make a general observation, but the commission always has, even where there's delegated authority, the commission always has the ability to call up for a vote any action, and that made by delegated authority, not just in the formal order space, but in any of the other areas in which there's delegated authority to the directors of enforcement. And we did see a number of instances of the commission doing that in the last administration, meaning calling up formal orders for a vote. And conversely, a director can elect not to exercise any delegation and send the action to the commission for consideration. Unfortunately, I can't announce any new policy at this time, but those are, of course, things that are being discussed internally.
Understood. I'll just note that when I first joined the staff of the SEC, which was in the year 2009, in the immediate aftermath of the credit crisis, there was intense focus on enhancing the efficiency of the SEC and eliminating unnecessary bureaucratic steps. And top of the list was to eliminate the need for people to write lengthy memos to commissioners just to have the subpoena power to conduct an investigation. And coming from being an AUSA, it was almost jaw-dropping to think I couldn't issue a subpoena without writing a memo that goes 7 levels above me to 5 commissioners for them and their counsel to review just so I could issue a subpoena. I do think that although it might be good for the defense bar, it's probably not a good thing for America to revisit that step, but we'll see. That's just me editorializing. Under Chair Clayton, settling parties were able to condition a settlement offer on the commission's grant of relief from the collateral bars that sometimes, or very frequently, are automatically triggered by many types of settlements, such as 9A of the Investment Company Act, which prohibits parties who settle to any fraud action from managing mutual funds. Acting Chair Allison Lee, I think, revoked that policy upon Chairman Clayton's departure, and I don't think it has been restored. Do you expect any change in this area?
Good question, George. I can't answer that.
Wells meetings?
No, it's something maybe I can touch on. We hit one finally.
Wells meetings. Well, there's 2 other topics I'd love to cut. We have a minute and some. So, Wells meetings. I think under the directorship of Gabir Graywall, based on some statements that he made, I think there was a perception that the director and deputy director wouldn't participate in Wells meetings unless the enforcement action presented novel legal or factual issues. I'm not sure in practice that's the way it worked, but do you expect any change in this to the extent that the current practice is that the director and deputy director won't meet have Wells meetings absent satisfying that standard? Do you expect any change?
Yeah, I do. I expect we will revert to the position where the director and or the deputy director, or us in our acting capacities at this time will generally agree to have a Wells meeting, if a prospective defendant requests it, absent some countervailing law enforcement issue. I will note, although we're out of time, and I know it from working with you, George, when I was at Milbank, sometimes clients like to have a white paper process akin to a Wells process. I don't think we will want to have two sets of Wells meetings and Wells processes, but we're certainly looking to add more process so people feel they can be heard.
So a pre-Wells white paper that's highly substantive and addresses all the concerns articulated by the staff might be an available option, but if so, don't expect to also have a full.
I would suggest, certainly the staff should be clear about how they view a particular submission, because obviously defense counsel can make submissions before something more formalized that would go to the commission. But I would suggest both parties should be clear about what their view is of the submission.
I have one more. Soon-to-be chair Paul Atkins wrote an article in 2008 advocating that prospective defendants in SEC cases be given greater access to the SEC's investigative file. Do you have any sense for what the practice going forward will be? I think that division practice varies from office to office and unit to unit, and maybe even case to case in my experience. Do you see any change in practice there?
When I was head of New York office, I always encouraged staff to share information, whether it's, potentially transcripts of testimony, portions of them, other documents, evidence both favorable and unfavorable. I think it assists the staff in reaching the right result to have a meaningful discussion with defense counsel, and having defense counsel aware of the both sides of the equation, if they're otherwise not aware of it already, I think is actually productive for the process. I can't announce any new policy, and obviously there may be exceptions to the rule, but I think that's the mindset that I bring to the job. Regarding the 2008 article, I do think practice has changed a lot. I saw in New York a lot of people giving a lot of information and process to defense counsel in either a Wells posture or a pre-Wells posture. So, if you think you're not getting something that you need, then ask. But I'm not, again, to be clear, I'm not announcing a new policy, but this is just how I think of it, and how we're going to think of it going forward.
Antonia, thank you so much for your time.